Good morning. Happy Thursday. We're heading towards the weekend, kids, so keep strapped in. It's always amusing to me that when people are deriding me as being a first-year family law attorney, I'm just a first-year family law attorney. You know? Oh, but then I say something that hits the nail on the head or they can't refute. And next thing you know, I'm Alphabet Agency. I am back in the FBI, boy. The FBI must have a revolving door. I'm in and out of it so fucking fast. Problem with Johnny's little narrative is that there are people out there who are just people. Johnny's narrative, most of the narratives that you hear in our little community rely on a big bad other. The government, the police, some nebulous group of people who does bad things. They're the enemy. It's them. Could be the lizard people. Who knows? Who really cares? The point is that you need a big bad other. You need a common enemy. It doesn't matter that, there are police out there with different opinions. The police are bad. It doesn't matter that, you might say, oh yeah, vets are great, but police suck. Well, what about the police who are vets? What about them? Police come from all walks of life. Oh, the police are racist. What about the black ones? Because there are black police officers. What about the Indian ones? American or subcontinent of India Indian? What about the Asian? Middle Eastern? Oh, so are the police racist or not? I mean, it's a narrative that you'll see it common. It's politics, movements like this. You'll see it all the time. They need a big bad other. It can't be an individual officer or an individual person. It's got to be a big bad other. And the bigger, the badder the other is, the more you need people's help, the more likely they are to give. Because boy, don't you want to take down this big bad other? If we could classify the big bad other big enough, then it's going to include your particular big bad other. So if we can make it the whole government is against me, not a first-year family law attorney, but the whole government. Not a lot of people hate a first-year family law attorney. A whole lot of people don't trust or don't like the government. Makes it easier, doesn't it? Now you can get funds from a bigger group. Now it's all of us versus all of them. I am not saying anything bad about the Democrats, but they tried to make a coalition out of all the special victim groups. And it hurts their narrative because you've got some groups that are very intolerant of, let's say, homosexuality, and you have homosexuals. So it's a weird coalition. The Republicans do it too. They've got the conservative Christians, and they've got the libertarians. They've got people who want to control your speech to make sure you don't see the devil or hear satanic music or, I don't know, listen to rock and roll, whatever. No porn. And then you have the other group under the same party who just want to be left alone, to do whatever they want. And whatever they want might include watching porn, listening to rock and roll, not going to church on Sunday. So it's a old tactic, and it's just amusing. It is just amusing. In order to beat me, he's got to try to make me into the FBI. Well, I'm sorry, Johnny. At one point in time, you gave me your phone number. You wanted me to be your friend. how times have changed. Anyway, let's talk about questions of fact and questions of law. The rule of thumb, and it's a pretty simple rule, the rule of thumb is that the judge determines what the law is, and the jury determines what the facts are. And so in our particular situation that we were talking about it yesterday, where there is a question of whether or not a statute is or isn't constitutional, that is going to be answered by a judge, because that does not deal with any facts. It deals with two laws. Does this law preempt that law? It's a simple question. It's an easy, well, not a simple question, but it's a straightforward question where the judge can look at law A, see if it does in fact preempt law B. No jury needed. You'll see questions of the constitutionality of various things done, usually in the suppression stage of a criminal trial. There'll usually be a suppression hearing, and the allegation will be that the officer violated the Fourth Amendment rights of the defendant. And that will be heard before the jury's impaneled, and a judge will make that determination. In a civil case, a judge is going to determine whether or not a particular law, if you're suing, like Metsumishi v. the DHS, they settled, but a judge would have heard that. That would have been a question for a judge, not a question for a jury. Is that particular practice, is that something that violates the First Amendment? I've got a dog half wrapped up around me, and it's rubbing the back of my knees, and it's bothering me. Anyway, where to say though that juries don't deal with questions of law is not 100% true. Where the facts meet the law, that's where the jury comes in. And so it's not really a pure question of fact. The judge will tell the jury, in the jury instructions, what the law is, what the elements are, it's called a jury instruction, and he'll say, did the defendant commit burglary? And you have to determine that the defendant broke into a building, that he entered the building, that it was at night, that it was a dwelling of someone else. And you have to also determine as a jury whether the defendant intended to commit a felony inside the dwelling. And so the jury is going to look at the facts, and they're going to say, well, we think he did break in. He moved the window. We determined that he moved the window. We determined that he broke. His fingers went inside to peer in, to pull himself up to the edge of the window. So we say that he did, in fact, enter. And we also determined that since somebody else lived there and not him, and it was a house, that it was the dwelling of another. And it was at 6:02 p.m. At 6:02 p.m., I don't know, is that night? I mean, it's still light out. I don't know. So we're going to say that it wasn't night. And therefore, we as a jury determined that this defendant is not guilty of the crime of burglary. They've just determined that he did not commit a crime. That's a question of law, but it's a question of fact. It's looking at the facts and applying them to the law. So if it's purely a question of law, it's going to be dealt with by the judge. Objections to evidence, purely a question of law. It's reserved to the judge. The jury won't hear it, can't hear it, don't hear it. Appellate courts. I had Megalodon, Mega, whatever he is. He's a retard. He jumped in with the wonderful observation that judges and appellate judges are jurists, not understanding there's a difference between a jurist and a juror. A jurist is a judge. A juror is a member of a jury. But appellate judges, they deal with questions of law. And they don't really deal with the facts. Yeah. But they deal with the facts. They just don't determine the facts. They accept the determination of the lower court or the jury in the lower court, and they make determinations of law, and there is no jury there. Supreme Courts, California or the US, again, there are no juries there because they're just dealing with questions of law. Assuming the facts as given, can you actually come to this conclusion? Or if they're just looking at a law, is this law or is it not unconstitutional on its face? Or is it unconstitutional as applied, etc.? So it does get a little squishy. But who is going to determine whether or not the regulation for the VA is or isn't, or the policy of the VA is or isn't a violation of the First Amendment? And that is going to be a judge. It's going to be a judge that's going to determine that. It's not going to be a jury. So I know it's a tricky subject. There's a lot of little caveats in there, but I hope that kind of clarifies because somebody was pointing out a couple other states that have insertions into their constitutions that juries will determine questions of law, but it's at a specific spot. They'll determine the law and the facts, how they work together. Like there's a legal definition of contract. Like you need these three things to be a contract, or whatever your state requires. States vary, but you need in order for a piece of paper to be a contract, it has to have these things on it. And a judge can tell you what those things are. But a judge can't tell you if this particular piece of paper is or isn't a contract. That's a question for the jury. So the jury will then take the definition provided by the judge, and they'll look at the piece of paper and they'll say, yes, it is, or no, it isn't. Anyway, I hope that clears things up. If it doesn't clear things up, well, you could ask for your money back at the door. How about that? Anyway, thank you for watching. I think I've babbled long enough. I've given Ted Nugent plenty of time to take care of business. Thanks for watching. Have a great day.